Please, Your Lordship. Your Lordship, with the consent of the other side, I beg to mention the item number 43, Your Lordship.
B. Why you need an adjournment?
Lordship,
Why you need an adjournment?
Lordship, ill health of the youngest councillor.
Huh?
Ill health of the senior.
For the apple?
Yes.
Take it round. Okay. Will be tested after 2 weeks.
Okay, sir.
My Lord, I beg to mention item number 22. The petitioner's advocate is not well. So,
Item 22. There are order that. Okay, order. Okay, it will be tested after 2 weeks. One, 9. None appears. Oh, last time. Yeah. Last order, so none appears not for. Oh, none appears. Yep. Check out. Today we have any
Yes, one item 48.
40?
48. Dispose of IA along with dispose of
What? Item number 48.
48 in orders.
Okay, see. Now 2. Is that item number 2? Or in 48?
48.
Achha, okay. That's
Okay.
no, okay, 48.
Oh, 14. Oh, yeah.
Keep.
Before I start, Lordship, there are a few inadvertent error that has been caused in the typographical errors. So here it has been mentioned in page number 2, cyber PS case number 9,
Page number 2.
page number 2, paragraph 1 in my petition in the IA.
Achha.
It should be crime branch. It is not cyber PS case number.
It should be crime branch.
Yes. So
Another other
similarly in page number 3, para 4.
number 3, para 4. Yes, there also. Case number is
Pardon, my lord. Page number 4, para 5.
para 5. Yes.
Para 5, cyber PS case number. It is highlighting. It should be crime branch 09.
Crime.
So my lord.
In place of cyber PS 12, it should be
No,
crime
no.
branch.
Cyber PS 12 is there, but
Then?
09 is crime branch.
No.
My
Cyber
lord,
PS.
my
in the
problem
first
is that, my Lord, in the petition earlier, Your Lordship, the order passed by Your Lordship is correct, crime branch. But now in this IA, he made this mistake, my Lord.
Means this typographical error was there in the petition in this IA.
His prayer is, my Lord, different.
But prayer is different. Only fact is that before I start, I wanted to bring into notice of the lordship that in this paras that crime branch case has been stated as cyber PS case number 09, but it should be crime branch.
Okay, then in para number 2,
Para 2 and then in page number 4.
para number 2, it's a cyber PS. It should be
Crime branch.
PS case number 9.
Yes, yes.
Okay.
Similarly,
and number 5.
Similarly, cyber PS case number 09 should be rectified to crime branch PS case number 09 in para number 5, page number 4.
It is not the cyber PS.
Yes, it is again cyber PS. It should be crime branch.
Crime branch 9.
Yes, crime branch
Order please.
PS case number 09. That is the first part. Now coming to the prayer section, my lord. Kindly peruse to page number 12. That is the Honorable High Court's order in passed in bail application number 4312 of 2023. That is the main bail application where this IA has been filed. Here in this order, my lord, the petitioner, the applicant was given time of 7 days to record his statement before the concerned IO. Now, what has happened is that in the meantime, when he was about to go and record his statement, he came within the knowledge that there has been another FIR where he has been implicated. That is cyber PS case number 12. So, since he was arraigned in that particular FIR, so he wanted to prefer an application in case of that particular cyber PS number 12, which he did before the honorable court, and here an interim was granted to him. That was on kindly page to page number 20. That is the interim which he was granted in AB number 741 of 2024. Page number 20. So now, my lord, this petitioner, since he has not recorded his statement in Crime Branch PS case number 09, because he was arraigned in another FIR, subsequent FIR, that was Cyber PS 12. So he waited for some time so that he could prefer this application. He preferred it, approached his honorable court, and interim has been allowed. Now he wants just 7 days of more time to go and record his statement in the Crime Branch 09 case, Crime Branch PS 09. Only 7 days of time, because he intentionally he did not wanted to go and like he did not wanted to not cooperate with the investigation. It was only because of the fact that he came within the ambit of the knowledge that he has been again arraigned in another FIR. So he wanted to get that relief from the High Court. He has already got the relief. Now he wants to go and record his statement. Just 7 days more extension is required in perspective of that order that was passed on 7/2/2024. That is the only prayer here.
Yes, my lord. I will leave it to your lordship, because my lord, your lordship has already
That
done
since the order was passed on 7,
7 to my lord.
since 7 2 months already left.
Yes, my lord, that is absolutely correct. Now, only fact is that since now
When his knowledge was there about the case, another case that it is
that came that in that part when he was about to go and record his statement.
Page 20, my lord, that order. Page
page
420.
20 is there. But the question is that in this the mention of cyber PS is in the order passed by the 7 in order to 7 to 2024 itself.
Yes, but he didn't knew that.
Order of the cyber PS case number 12 was there. That means it was there.
No, my lord. At that time, he didn't knew that he was there. He came only for 09.
Cyber PS 12 2023 case in the order.
Just a minute, my lord.
Because in the order, as you have submitted the reflection, the cyber PS.
Yes, my lord. That is the order that was passed on 8/4/2024. In the subsequent AB application, he was granted that relief. Not in 7/2, he was not. He didn't had that knowledge that he was implicated in cyber PS case number 12.
Now, you want to your prayer is only for extension of that.
Yes, yes. Only
Or why you have pointed out the cyber PS crime branch, all these things.
pardon my lordship.
Because, my lord, while filing this IA, my lord, he made mistake that he has written as cyber PS case number 9, but actually, my lord, he prayed for extension in the order dated, my lord, wherein against, my lord, crime branch PS case number 9.
Yes, yes.
While filing the present IA, my lord, he made all these mistakes here, my lord. So those things are, we need to.
So in our order, it is crime branch 9
Yes,
only.
that
Yes,
is correct,
yes.
sir.
So you have pointed out crime branch 9, PS number 9.
In his petition, my lord,
In-
now
in-
I-
Your petition
Yes,
is
yes,
valid.
my lord. In my not in Honorable High Court's order. In my petition.
We note it down for I am
hold কৰি দিছে
Why, what W stands for in your name?
Ritu. W is silent. W R I.
Oh, that's why. Otherwise, Ritu is RI.
Yes, yes, yes.
Here your is the WRI.
Yes. Some sort of connotation was there from my parents' side.
Oh. So there are most probably very few names starting with
Yes,
W.
yes, yes.
But, uh, but, uh, God. But, translation of order. It of 907. But, if the 41 whereby petitioner was asked to appear, I state of order in and so this paper is case number 9 and 1 4 9 4 0 4 7 1 4 9 number 21st of and 4 from case another FIR that has cyber nothing 1 4 9 9 of I
তুমি থাকিবা নেকি?
however, again, for
অলপ,
for the seed cyber red white hot food was run fight for tank. I at person ordered set food party for food one sub by art and person that that okay we are giving you 17
Yes,
right?
madam.
There call case diary was called for.
in that case, my lord,
That is what is the position now?
yes, after perusing the case diary.
Oh, it was after printing this diary.
After perusing the case diary.
Oh, acha. So that was final disposal. Matter was disposed of final
Matter was
Yes,
disposed of.
yes.
Disposed.
Oh, but not an interim.
Not in.
Not interim. Okay,
No.
that case to appear.
Yes,
Abide by all terms and
yes, yes. Obliged, sir.
Lordship, I am for response number 3 on the
or respondent number 3. To appearance on the last page and also appearance page.
Lordship.
Is there any order of admission? No.
No, no.
No. No. Your Mr.
Yeah, that.
Yeah. It from the order that we have to definitely for the for 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 it's okay.
May I please ask? This appeal has been filed under Section 173 of the Motor Accident
Hmm.
Claim 88 million, telling the judgment award dated 30th 5 2017 is passed by the learned a member Motor Accident Claim Tribunal, Asar Shilsar, my lord. My lord, lordship will find page 5, my lord, my ground, my lord. What is, my lord?
Yes.
Roman 3, my lord. For that, the respondent number 127 claimant filed the claim petition under Section 163, capital A of the Motor Vehicle Act 1998, 1988. But at the time of passing the impugned judgment and claim petition of the respondent number 127, it has been converted and stated the application under Section 167 of the Motor Vehicle Act. The learned tribunal thereby hold that the respondent number 127 claimants are entitled to compensation under Employee Compensation Act, but the respondent number 127 claimant failed to prove the deceased was the employee of the appellant. And the deceased was the handyman. They are saying this was the handyman, my lord. I am
As
the
per the landed member that it ought to have been filed before the employees.
my lord. Yes. Well, the respondent is appear, my lord. The matter is admitted and hearing. Please for hearing, my lord.
So you are appearing for
1 to 7. Also, I am very furnished with copy of the memo.
Yes.
Today's set.
an ATT company, national insurance company. That's
Madam.
for number 8.
My lord.
170 has already
Yes,
appeared.
yes.
I'll repair, my lord. I'll repair. Yes, my lord. I'll repair. Yes,
You name not
yes, my lord.
hard to get. But there was a conversation.
Yes. I'll
But 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 well, but the response number 1 where Only that before employees compensation act,
Act.
but where so your petition was rejected. Claim petition.
No, no.
So what your
It
was
has
converted.
converted, man.
Ah.
Converted to compensation act.
So for the state compensation, you are you're getting what was the amount of the awarded amount?
3 lakhs 32,705. Page 18, my lord. Para 33.
So 1.7, you are the claimant.
Lordship.
Oh, you are the owner of the.
My lord, man. I'm restaurant.
That is whereby whereby claim has been treated as an application one and other employees company. It is not.
Oblas.
May I please, your lordship? N. Ahmed has returned his brief, lordship. Our fee name may be struck down in the instant case, lord.
Return okay,
Yes, lordship.
but
N. Ahmed, lordship.
Anna
N. Ahmed has engaged our tea council, lordship, and he has returned his brief, lordship.
to you.
Yes, lord.
So now you are the accountant.
No, I'm not a council, lordship. N. Ahmed engaged our tea council, lordship. He has returned his own brief, lordship, N. Ahmed. So, your
Now
lordship.
you will be the engaging counsel.
Yes, lordship. Three council name may be struck down in the instant case, lordship. B. Buragoy, P.K. Gogoi, and Zepi Gosai, lord.
Now JP
Zepi Gosari, B. Buragoy, and P.K. Gogoi engage council, lordship. N. Ahmed engaged the instant case, lordship. And N. Ahmed has returned his brief, lordship. That is why our name may be struck down in the instant case, lordship.
So I'm not following you. And Ahmed was the earlier engaged counsel.
No, lordship. N. Ahmed, in the instant case, N. Ahmed, lordship. Our tea council has been engaged by N. Ahmed, lord.
Now what had happened?
Already N. Ahmed has returned his brief, lordship. Our tea council.
May I help? What he means to say is that they were engaged as counsel in the case.
Yes.
Now they have returned the brief to the
N. Ahmed.
N. Ahmed,
no,
lord.
no, to the parties and whatever, N. Ahmed or whatever. And now I think that for that, I think he has to show that he
Yes.
has returned the brief, Lordship. And but he means to say is that they have returned the
Brief to Ann Ahmed.
Yes, Lord.
You have returned your brief to Ann Ahmed.
Yes, Lord.
Now Ann Ahmed is the engaged counsel.
And Ahmed engaged ourselves, Lordship. Three council.
Anahmed
Sorry,
engaged them.
Against
A
them.
council, not the party, a council engaged them.
Lord.
And now they have returned the brief to that particular council. That is what he is saying. But Lordship, High Court rules, they have to follow. They have to get a. Yeah.
So now presently Ann Ahmed is there. You too want to withdraw yourself, but Ann Ahmed is there.
Yes, Lord.
I have-
You are Mr.
P.K. Gogoi and B. Buragoy and
No,
J.P.
you are
Gosai.
Mr. PK Go.
Yes, Lord. B. Buragoy is also my senior counsel, Lordship. And J.P. is also my colleague.
You are PK Go.
Yes, Lord. J.P. Gosai, Lord.
As the counsel for the return, Mr. Ann. Great. In the name of the council of God, as they are not have there is no there's no notice or other file a notice. You have already noticed it? Yeah.
Yes, Lord.
No, appellant, you have filed your you have submitted. I mean, you should notice to the appellant that we have already withdrawn ourselves from the.
No, Lordship. Already Ann Ahmed engaged me, Lordship. Actually, brief is Ann Ahmed, Lordship.
So, if Ann Ahmed has already engaged you, then why don't you appear for the appellant?
Already, I have handed over the brief, Mr. Ann Ahmed, Lordship. I have no brief at that present, Lordship. How I conduct the instant case, Lordship.
How the done it outcome for the detail of the name of this other and this not his name along with the other and this not Mr. Burago. You do the formalities.
Lordship.
All the formalities you do and submit on the next week. Next after 2 weeks it will be released.
Lord.
Because the Ann Ahmed is also we have not found him.
Lord.
He is also not representing the appellant.
Lord.
So the next day, after observing all the formalities, you file a thing and we will pass the order of
Lord. I love it.
Yes, Your Lordship, this appeal I have filed, my lord, against the judgment and decree dated.
Lordship, I'm yet to receive the copy of the appeal.
No,
Lordship.
how can the appeal has not yet been admitted? So how can I give you a copy?
No, before admission only you have to give.
Notice has to be issued first. Then only I will give.
So you are for the respondent number
1 and 2.
1 and 2. So both the respondents you are representing.
Yes, Your Lordship.
Otherwise, regarding the admission, you have anything to say, then we will pass an order for admission here.
Lordship, I don't have the anything. Lord.
Anything.
Yes. I have to go through the file, Lord. The RFA along and the IA, Lordship. One IA is also.
No, this is a facts and matter of facts and law. So let the matter be admitted and let the notice be sent. Lower court record be called for. One time it will be disposed.
So he has already appeared. So provide otherwise, but okay.
Yes.
But the question he has already appeared. So he may have something something.
My lord.
See, he may have something to say
Yes, yes.
in regards to the admission.
Uh-huh.
So we'll list the very short date. We just provide the copies. We'll list. because already your notice, the formal notice is not required. He has already appeared.
And
So notice part is okay. He has
Okay.
already appeared.
Yes.
So the question is, Paki, you hand over the memo of appeal
Huh.
during the course of the day, and we'll list it for the admission. Coordinate.
And then later, okay, that will be.
Not part of Mr.
W. Sharma Law.
So how we have appeared? Was there any caveat? Was
No, lots of delay condition application was
oh,
filed.
there you have appeared.
There, yeah.
Oh. How it of the memo. Hereby that of record for. You want any fitted or after 1 week?
Any after 1 month, after 1 week,
After 1 week? Because it is not admitted that
Yeah, yeah, yeah.
or after 2 weeks.
after 2 weeks, after 2 weeks. Later, IA LCR, because I filed IA also. For that also the LCR is required. Order 40 or rule 27 I filed one petition.
And the call for the okay. Item 6. And it according to
May it please your lordship. Your lordship, this matter may kindly be taken up after some time. Engaged counsel is on legs in our report. Obliged, Your Lordship.
May it please your lordship. This is an appeal against the.
Lordship, I have received the appeal memo few moments back, Lordship.
So, this is a statutory appeal, lordship. I do not understand what they are going to do. They will file an affidavit in opposition like writ petition.
Lordship, they have even will file IA in this case
I on what?
for stay.
For stay. Lordship, we are filing the appeal. They'll file a I for stay
No,
of
no,
the
no.
judgment.
We are not filing. Will you file? I'm asking you.
if file, they may not file.
If they file, Lordship,
No,
come
still
with
we are
the
not having any IA at present.
Yes.
At present, till date, there's no IA. So it's a statutory appeal. It can be admitted. I think
It can be admitted, Lordship, with the liberty to directing them to deposit 50%.
so if they do not, if they do not want any stay, then how can you ask them to file an appeal?
So,
You are at liberty to file there for the execution of the matter because they are not seeking for any stay at present till now.
Yes.
They may file.
Yes.
They
Exactly.
may not be. That is different aspect. But till now they are not. So is there any other subject?
Lordship, kindly pass over for time being, Lordship. Senior
No, so
member
you are
needed.
not following. The question is that Passover is okay, but the question is that the statutory appeal. We may admit you have already received the memo of appeal. So this cannot be any bar for admission of the appeal. Let the LCRP call for, we hear them. But till now they have not furnished any, they have not filed any IA for stay, etc. So if they have not filed any IA, you are at liberty to file the execution. No bar. Till now they have not filed. Or is there anything?
Kindly take up after some time, Lordship. Senior member needed.
What is the use? Lordship saw that day also another advocate did that same thing, and after 1 week they say ki, okay, we do not have any objection in admitting that statutory appeal, Lordship. And I have told them that we will be filing I for the stay. But appeal, why the appeal should wait, Lordship? Because it is their own case is from 2017. The judgment was passed in 23. Delay was condoned in 24. And now it has come for admission. So why delay? They are delaying their own case, Lordship. Admission, they should not have anything. It is
will
a
not be, will not be trouble because question is that if they file any, suppose the stay petition or IA, any, in that case definitely you can have your own say, or there you can raise the point of deposition of 50%, 60%, whatever. Those things will come at the time of I, if they file. But this is statutory appeal, it can be admitted and LCR can be called. I
It's
think
the court
will-
thing, Lordship.
Yes.
It's Lordship's discretion. They do not have anything to say in a
Okay,
statutory.
I have instruction to submit before your day, Lordship. In your action to submit before your day, appeal can be admitted, directing them to deposit 50% and with the liberty to withdraw it.
The question is, if they are not seeking any prayer, there was no prayer, there is no prayer till that regarding the stay of the appeal, stay of the process. I mean, stay of the award. So if you are still at liberty, file the execution. If they tomorrow they file the suppose IA, in that case definitely direction will be there to deposit the 60% or what.
Otherwise,
Because
they have.
we are not staying the matter. We are not going to pass any stay. Order on stay, we are not going to pass any order on stay. Can you follow me? We are not going to pass any order on stay at present because they have not prayed for any stay.
For death card, senior may be needed, Lordship, for some time.
Okay.
Wait, please. My lord, my junior colleague would like to argue this matter.
Yes.
Yes, Your Lordship. We have filed an appeal under Section 173 of the Motor Vehicles Act, challenging the judgment and award dated 20th November 2023, passed by learned member MSCT Kamru in MAC case number 1217 of 2018, awarding a sum of 30,88,528, Your Lordship. Your Lordship, in the appeal which you have filed before this Honorable Court, there are certain grounds of appeal, but the main grounds on which we would like to focus is that the learned tribunal below overlooked the fact and erred in law in assessing the loss of dependency, taking annual income of the deceased who was a government employee without deducting the benefits already drawn by the claimants under the scheme of the government of Assam, Your Lordship. Your Lordship, the learned tribunal ought to have considered the compassionate family pension scheme by the government of Assam, which is applicable to all the government employees who dies in harness on or after 1st April 2017, and the family of such deceased employee is getting family pension equivalent to 100% of the last drawn salary. Your Lordship, I would like to draw your focus to this notification,
In 2017.
which is there in page number 25 of the memo of appeal, Your Lordship. Your Lordship, this scheme for compassionate family pension, CFP scheme, it provides that any government employee while in harness, which means that while he is active and working before retirement, if he dies either due to natural reasons or unnatural reasons, they'll be paid 100% of the last pay drawn, which will be revised periodically as and when normal pension are revised. So, Your Lordship, the aim of this notification by the government of Assam is to compensate the claimants, the dependents of the deceased, and the same is the aim of Motor Vehicles Act also, Your Lordship, to compensate for the loss of income. So, Your Lordship, claimants, that is the dependents of the deceased, can on no ground be permitted to draw double benefits, Your Lordship, because that will be a source of income and not compensation.
So you are appealing for?
Lordship, I'm for the claimant. Respondent number 1, 2, and 3. 1, 2, and 3, Lordship.
One.
Individual, Lordship.
1, 2, and 3.
1, 2, and 3, claimant, Lordship. Respondent number 1, 2, 3.
Okay. 4 is who is 4?
Who is the owner, Lordship?
Owner. 5 you are
The
appealing.
driver, Lordship.
Driver.
Yeah.
4 and 5 are the owner and driver.
The owner and driver, Lordship. I'm Keviator, Lordship.
Okay.
Appeal may be admitted for deposit 50%.
Your Lordship, we would like to deposit 20% as of now.
I go to them.
Yes, sir. We have filed a stay application.
Are the stay beyond.
Yes, yes, sir.
your Mr.
K.R. Bora Lordship.
A.R. Bora, appearing on behalf of
Your Lordship, my senior's name may be recorded.
and also with Mr. R.K. Bhatt and K.R. Bora, appearing on behalf of one that the MP wants to executive about 2011 come and in
Lordship, NACT 1 Kamrup.
yes, member one.
1.
Member one come and in investigation for one that awarding some of that subject that member scheme of the government by 49% by getting 100% of that bit of PN of PN of tuition notice reference number 4 and 5.
4 and 5.
Okay, yeah, that's
Four and So in I, you are ready to pay 50%?
20%, Your Lordship.
To lesser Lordship. This case is involved 2018 Lordship. Surviving wife, daughter, and son. They are studying in
But
college
there is
and university.
yes, that is true. But the question is that now after the government scheme,
Lordship.
so there is
That will be
the
decided
dependency
that
part is not there now.
Lordship.
So that is there. One, but rest apart the other heads you may get. So whether it will come 20%, what will be the amount of 20% will be?
30 lakhs,
6 lakhs.
6 lakhs something.
6 lakh only.
Lordship
Make
may
it
be
on
Your Lordship, they are
30%
only
Lordship.
entitled to conventional heads as of now, Your Lordship.
conventional head, but 30% can otherwise.
25%, Your Lordship.
For surviving Lordship. Dependent.
Surviving in a sense for getting that salary.
That will be decided by. Salary is not a
Decided
Sokidar.
Huh?
So this is was a Sokidar Lordship.
He may be a junior, but he was a government employee.
The government
Same
at that
question.
time.
So under that scheme,
Your
he will get.
Lordship.
So
Your
at
Lord-
present, yes.
Your Lordship, he was a chokidar, but his monthly salary was 20,256 rupees, Your Lordship.
So 25% people,
All.
it will come around 7-8 lakhs or something.
Lordship may allow the withdrawer.
Yes, you will be at liberty.
Like, valuable.
Your Lordship, they may be directed to file an application to withdraw.
It will be verified by the registry.
Yes.
If it is not supposed, then it will be definitely. At the time of withdrawal, definitely they have to file an application before the registry and it will be verified and then ordered. Subject payment of 25% with part payment. That's the number one. It will take verified and on being verified by so within 6 weeks you pay the 25% of the awarded amount that will be
Highly
will be
obliged.
at liberty to withdraw.
Highly obliged.
I understand.
And Your Lordship, the notice
God.
to both ways, registered post and usual process. Okay. Much obliged.
Much obliged.
In this case also, this is was a company employee of Assam Nats.
Oh,
So Lordship, appeal may be admitted and regarding the Lordship, I will deposit 20% of the awarded amount.
if they are not here, so let us finalize the IA after their death. Will it be okay?
Lordship,
After their appearance, that especially the claimants, then we may decide the 20%, 30%. 20%, let us see.
because, Then
Same thing, I can understand. But what was the awarded amount? Last awarded amount?
The awarded amount is 35,78,809.
So 20% will be around 7 lakh.
7,15,761. We will deposit 20% of the awarded amount. In other cases also we are depositing 20%. Similar.
No, obviously there's a scheme now. That admitted. Registered. KK for not for the complete that gets for the date submitted for award the path by the scheme of the government under notification whereby payment 100% tax paid on admitted on in regards to liberty, do you want to say anything?
Let them file application.
That's why I'm saying that let them appear in the IMA with this photo. Okay. Let them appear then. But I think if not, because at present you are saying that liberty will not be done, let them appear. I agree to not. What?
To the Lord. This appeal is in file underground. The death did not occur due to an accident. The person who died was a driver. But it was a murder, Lord. Even before he reached the place of duty. It's a family war kind of. The claimant has said it. It's very on the facts also. The claimant's husband and other members of her family were attacked by the members of her uncle's family. Two families got involved into a broadcast and died. How can this be a case on that? They had filed a case against murder. And the claimant also, they have given evidence in the that GR case as a case of murder.
But whether,
How can this be?
Whether that person died out of the use of the vehicle or he was thinking that is there any sort of kind of that?
They said he was called by the employer, the owner of the vehicle. He was going there on the way. This happened. And it appears like it's two families. I don't know how far they probably had gone out to challenge each other, or maybe they were being chased and by the other people. But there's no element of accident in this.
My lord, this aspect has already clarified in the judgment, my lord.
That's the part I'm challenging, Lordship. The Lord member has described the EA, but his finding is not correct, Lordship. Accident, murder may be unforeseen, but that cannot make it an accident. No one is planning a murder, at least so far as the claimant is concerned. He was killed because of an existing family dispute. And it's clear. On the evidence of the claimant also makes it clear. The accused persons were her relatives, her uncle's children. Some of them are in jail also. Some of them are in jail also.
One thing, if the matter has already been clarified by the learned member, maybe as per your subject, so we'll see to it and all. Let the matter be admitted for hearing. Call for the LCF and we'll see whether it is a case of
admission hearing
can be compensation can be given under the Employees Compensation Act, or it is a complete murder. Suppose
that may be given, my lord.
Only,
my lord, 50% may be given at this time.
If admission hearing, it will be next week, next month.
There
It can be fixed.
Specific law also, my lord, in this respect. Section 29, my lord, of Workmen Compensation Act.
So that is there. question
Yeah.
difference. Question that
And he filed an IA also, my
29
lord.
yes, 29 is there, 30 is also, as per 30 is following, and 29 is also there. But the question is that the challenge the question that it's a purely a murder case.
My lord.
It cannot come under the purview of the compensation or whatever. That is their subject. But in that case, if I don't know, Mr. Guptami, if you want to submit,
Lordship, I think it will be better if the matter is disposed of at the admission stage. Next month, Lordship. If the records come, next month can be so either he gets in full, or others if a stay is granted, then it will be it will go for hearing. It will go lingering Lordship for a very long time.
So we are not going to pass any order on IA now at present. It will be there only. So let the matter be listed after 1 month, and till receipt of the after receipt of the thing, to try to do it after within 1 month. So now you are for the 1, 2,
All the respondents.
1, 2, 3, 4, and 5. Who is 6? 6 is the owner.
Oh no, Lordship, he has to be there.
He has to be here. That's what. 6 is the owner, I think.
Owner,
So
Lord.
notice
I mean, out 1 to 6 appeared already.
no, you have appeared for 1 to 6.
1 to 6, my lord.
How can this
So
be?
you appeared for on behalf of 6 also. He is the owner or
No, my lord.
that's
And there's a mistake. He can appear for 6. The others are.
what you are appearing most probably 1 to 5.
1 to 5, my lord.
Huh?
1 to 5, my lord.
Is it?
Sure. Record 1 to 5 now. 1 to 5 is the
Otherwise,
agreement.
we might be in difficulty because otherwise we are going to issue notice on 7/6. So if you are appearing for the claimant, then obviously for 1 to 5 should be
The notice has gone to 6, Lordship.
1 to 6 also.
Yes.
You are absolutely.
Problem. Yes. Picture है तो मैं dusty cover करती देखिए yes 6 8 8 we are allowed to take steps by dusty on response number 6 because for the time being
Hearing, na? For 6.
are you appearing for 6 make it clear otherwise to go take
My lord, sometime I will check the records, man. Sometime, only 5 minutes.
मुकदमा कहाँ है
But in delay condonation, he appeared for 1.
1 to 6 I think it has to be 1 to 6 only.
Subsequently, I filed one Wakalatma for
1 to 6.
perhaps.
Okay, we'll check. 1 to 6 is 1 to 6, then it is already 1.
That is the reason why I think it was delay was condoned because all parties have appeared. It appeared that all parties have appeared.
FLS.
So I have now tried to propose to here.
The Wakalatnama which you have filed connected with the delay condonation, there you have responded for 1, 4, and 5. You make just clarify these things. So the TH Mojumdar is also there.
DS Muzumdar is there, man.
But TH Mojumdar is 1, 4, 5, and 6.
6.
So you are appearing for 2 and 3 also.
All the respondents, my lord. Subsequently, I have filed for 3, 4, and 5, my lord. These are minors, my lord.
So one thing, we'll pass an order for issuing notice on response number 6. By that time, we'll hear the LCB.
If the signature of 6 is there under Wakalatnama, then I think it can be taken as is.
1, 4, and 5 only.
6 is 9. Signature of 6 is not there.
My lord, kindly check for 1 minute, my lord.
You want to take the 5?
6 or so he has to be appearing for it.
Argus. Against its judgment and order was by Planet Court, employees compensation, Bongai County, in PC number, PC case number 12. It's a that this died. This was murdered after and it cannot come under the purview of the order, the judgment and order was granted commissioner.
First, we will fix
six. I am
we
not.
will have to take steps on 6 because his signature is not there. But Justice Lordship. But
It's immediately. We have to check it immediately after listed property and we are not passing any order on IA because it's A and not. We try to go the on the next.
My lord, in this, some observation may be given for disposal. For disposal.
Okay.
Oblige.
oblige.
Thank you. Well, yeah. Okay. Yes. Huge on the earth. United. Seven. An application for. Yep. Well, because the same button. Then you call for 12 or all 2005 or a bit.
I'm for the respondent, my in item number. No? 40 in I am appealing on
14 and 18.
14 and 18. Mostly the railway, I think mostly they have also lost their interest to pursue the matter.
Yes,
My lord.
that's what I'm saying. Because none has appeared the matter of 2005 in fact.
Well, my lord. Independent the respondents in case number 12
of 2005.
12 or 25 actually expired. The respondent expired, my lord. No substitution, my lord. The same as
Already appeared, expired.
my lord.
Oh. In
12
item number 15,
12, 15 and 16. Respondent expires, my lord. There are no substitution is till now, my lord.
No, now you are appealing for 14 and 18.
14 and 18, my lord.
And as per your information, 18 the respondent died.
My lord.
No, but who?
No, it's not 18, my lord. You don't know? 15, 16, and 12, my lord. 12, 15, and 16. As per the office note, my lord, I have collected them from the information, my lord. There is a report. The report is my lord.
The 12 with also an April file back.
N file malo. All cases malo.
No, I'll consider yes, but in 12 also one died.
12 also. 12 also malo.
Huh?
12 also respondent died malo. Respondent claimant.
Respondent claimant that there is and others are there.
Oh,
So maybe 2, 3, maybe 1, 2, I don't know.
No, in 17 I am appearing malo. 17 no?
No.
17 too. Sorry malo. 14 and 18 malo.
Okay, this that appears not also happen. It before 8, 12, 11, 12, or a non 14, right? Non 4.
No, no.
How about but in 14, no one has died now.
No, no malo.
Appeared here.
Only malo 12, 15 and 16 malo. Respondents died malo. 15 and 16 also.
Right, but most probably in two matters, 15 and 16, you are not appearing.
No malo.
So you cannot record your
No
submission.
malo. No malo.
15 and 16.
Just my for the
Yes,
of
yes.
the court
Okay.
malo.
No, it's okay. 15 and 16 same order. None has appeared. Chapter 4. 17 also the same. One none appeared. 18 you come. None appears. All but submit. Now you submit who died in fact in 18 as per your information.
No, 18 no, 18 no. 18 is alive malo.
18 is alive.
Yeah, alive malo. Only 12 for 15 and 16.
Oh, 18 is alive.
18 is alive.
Oh. This time. So these are all 5 meters, but railway most probably as per your submission, most probably railway is also not interested.
No, not malo.
Maybe. So
Based on another date may be a fixed malo. On the date is nobody appears. Then in that case, court may take a decision about malo.
will not on the if the consequences for the data. Is 19 not the same? 19 is also 11. 19 you are not appearing.
No.
19 to same order. For the consequences out of parts.
Okay. Publish. Look. Make that up.
What? All right, separate. 4 separate order.
May it please your lordship. Your lordship, in this case, respondent number 1 and 2 has already entered appearance, your lordship. LCR has also been received, your lordship. So it may be
1 and 2.
Yes,
I'm
dear
for
respondents.
one, my
You're for 1, you're for 2.
one.
He is for 1.
He's for
For 1.
my
You have
colleague.
other entered to tables 2 also appeared.
Yes, your lordship. Your lordship, we perused a court order dated 29/8/2014, your lordship. Respondent number 1 and 2 has appeared. And they have also filed a wakalat number.
Oh, one date of our
No,
LCR authority.
SCR has been received, your lordship.
Not your Mr.
H. Gogoi.
As Google.
H. Gogoi.
H. Google. One. It appears from the order dated 9/14 that respondent number 6 also appeared at this not the fact of here after it's a certain matter.
In
No,
due
it's the
course.
case. It's the 13th.
Yes, sir, but it is an old matter, Your Lordship.
So after 2 weeks,
Yes, Your Lordship.
they're going
Obliged.
Obliged.
May it please your Lordship. Lordship, LCR is still not received by the court.
Otherwise, your service is completed.
Yes, Lordship. I think so.
What? Heard
Jai Vizura.
if it would not done for the it's not the it's not dated 21/3/2024 that even after within just of reminder, the LCR has not been received by the BHP. I saw this date as Shoko data reminder be along with the Shoko not required. Even after repeated reminder, the LCR has not required for the office, the constant section of it, it's accordingly after court. So going to propose the
Lordship. Obliged.
May it please your Lordship. Lordship, in both the cases, LCR is received.
put the matter as a held
Yeah.
and you are appearing for
Respondent number 3 in the Boda case, insurance company.
And other respondent already appeared, Lord.
appearance there. Your Mr. A.
A. Hussain.
Or Mr. A order computer or Mr. A. Both the same order. Not hard.
A authority.
A. A. Done on the pin. A. It's a bit all as well as and record the record after trip
In admission column, Lord.
not admitted.
No, no, no.
Oh, okay, admitted.
No, sir.
It was listed for lodge in Mata. Thereafter, after due complete appear court, but uh, from office note date 2004. It is seen that can appear before the law of court, nor can it state on respond number 2 to register it and electoral process. And accordingly, he, as per the order of law of the matter. Today also the appellant remains absent at stake. This accordingly after 2 accordingly after and the applicant is further directed to take steps to the content number within 7 days.
May it please, Your Lordship. This is item 25. Lordship.
Yes, yes.
Lordship, I am on behalf of S. Roy, Mrs. S. Roy. We need 1 week time, Lordship, in this case.
The question is that it was placed before possibly Lauzima court, and as per the report of the Lauzima court, they have not, appellant has not taken any steps to respond number 2, though order was there. So that's why again it has been placed.
Then, Lordship,
so we have passed the order to take steps within 7 days, and then the matter may be listed.
Lordship, obliged. Only Mrs. I am on behalf of Mrs. R.
Okay,
so non-appears may not be recorded.
Archer.
Obliged.
Yes, Your Lordship. Lordship, as per office note dated 12/3/2024, AD card has received written answer on respond number 2, Lord. So I may be allowed to take steps on respond number 2 to Dusty.
And you are for?
I'm for the respondent number 1, my lord.
1.
1, my lord.
2 respondents are there.
Gotcha.
My lord, I have filed a IA petition, my lord, with a pair to directing the appellant to deposit 50% of the awarded amount, my lord. They have not deposited the awarded amount before the rest, my lord, till date, my lord.
Actually, kindly see the order in IA 2279.
Appeal is already admitted, my lord.
Order dated 6/12/2023. The direction is to this IA will consider at the time of hearing of the appeal. So there is no question of depositing 50%, or there was no direction to deposit 50% because there is a status quo order in stay petition. So at this stage, Lordship, I will take steps on respond number 2 for the stay, and after that, the matter will come for hearing, and same I will consider.
My lord, there is a mandatory provision, my lord, section 30 of the Employees Promotion Act, my lord. Third, may I read, my lord?
There is what is the intent?
Lordship,
Was there any interim or
interim status quo order is there, Lord. In IA.
status quo is there?
Lordship. In IA 1304, 2020. (39th 2020 order.
So there was a status quo.
Lordship.
One observation has got to be made by the court defense.
Yes,
That
ma'am.
matter may be considered at the time of hearing. So in that case, if you want any to order to pass, then it has to be placed for the applicant. Otherwise, an order has to pass by the court defense preparing that order. Pass the order. That's why I'm saying. That's nothing. So if you want, then it will be distributed for the applicant. If you think that there should be an order.
My lord,
Otherwise, there is an observation that the interlocutory application may be considered at the time of hearing. But as you have submitted that, there is a specific provision may be there for stay for for deposition of some amount. But the question is that already observation is made. Why don't you, in that, and by passing this order, have you by making
yes, I have
your
gone
submission
through
in that
for
regard?
this order.
That
Yes.
case, so
My lord, question
so
is, my lord,
whether it can be days before the appropriate time, or matter may be heard along with the doing. Think that we'll pass the order before the appropriate time. Is the listed before appropriate time? Okay. Then in that case, he may the matter and may pass the order.
In the meantime, I will take steps.
Actually, my lord, the provision section 30 is there is a provision, my lord, provided further that no appeal by an employee under clause A shall lie unless the memorandum of appeal is accompanied by a certificate by the commissioner to the effect that the appellant has deposited with him the amount payable under the order appeal against. My lord, this is the provision. My lord, they have not deposited the amount before the Assistant Labour Commissioner till date. My certificate was not issued by the
certificate is not accompanied.
Yes, my lord. That's why I have to file this higher.
Do one thing. We make this before the appropriate time within this week. You take steps in the when not going past any order, so that the matter may be heard.
Okay.
Because the certificate is also not there.
Yes, ma'am.
Shorted we are giving. We are giving 3-5. 3-5.
Okay. May please, Lord. In this case, I am appearing on behalf of the appeal party number 2, my lord.
Yes.
I require a 2 weeks time to file our reply to the interlocutory application filed by them, my lord, for a conditions of delay, my lord.
How many days did you put?
37. 35 days, they have said, my lord. But I will receive more days, my lord.
So can it be conducted?
No, my lord. So I will have to file an reply, my lord.
37 days only.
Even them, my lord. According to them, my lord, it may be more, my lord, according to us, my lord. Let it, please have escape our notice, my lord. We have received in the last year, my lord, a copy of this application.
You are Mr.
HK Sharma.
HK Sharma, hard stage, not debit. Not that of debit. Support time. By accordingly, how many times?
2 weeks time, ma'am. 2 weeks time.
2 weeks time.
Weeks.
It's according.
Much of it.
May please be Miller. Lordship, reminder was issued for LCR. Yes, Lordship, reminder was issued for LCR, but it has not come. So again, reminder may kindly be issued. I believe it's the commission.
Two, three reminders are there, Lord.
In one case, Commissioner, they have sent the LCR actually
of a different
not LCR there, not accompanied with any original document, nor the evidence, nothing is.
Oh.
So that's just Rana made an observation. Now again they have not there's no such record with the original any original document.
So how did they pass the judgment?
How to pass? The maintenance of records, there's no such bit. That's why that is the here. So just now we have passed an order. We had to in fact locals also. So they are not appearing. They are not submitting the LCR for last 4, even after 4, 5, 6 consecutive. Reminders.
Very, especially these MFA cases, like WC cases.
from the office note dated 19/3/2024. It's seen that LCR is not received despite repeated issuance of remand. Operation submit LCR on or before date. Before date, date.
Earlier.
It will be dated with after 4 weeks.
Yes.
So 129 is the cross objection.
Yes. That we have filed. 28. No, in that same 28 itself, the cross objection
one is 9 is there. Oh,
yes,
that's
19 of 22. It is there in the same. Lordship, item 8 I'm sitting, they have not.
Yeah. We'll record your submission if they come. The question is that is a statutory appeal that is
Yes.
I put to
Because Lordship already heard what he has to say. Lordship, I gave that example. Same thing happened, Lordship, with the other case that day. Mr. J. Ahmed. On Monday, he says that, okay, I have objection, I'll file objection. And Friday, he comes and says, there is no way Lordship can admit. So, I mean, I'm waiting because I have 44 also.
Okay.
29 Lordship, office note dated 23/2/24 says that service report in respect of 1 and 3 has not come, so we can wait. Lord.
No, they have not taken step.
Yes, yes. I'll take then first step, Lordship. But office note dated it is not returned. I've taken a step.
Oh, but it's a cross
Cross
objection
objection.
along with MFA.
Lordship. Office note dated 23/2/24 Lordship. That
But you already appeared for?
I am appearing for the
2.
For 2. You have not taken stage.
Lordship, 1/3 not returned. He mentioned order dated 23/2/24 Lordship.
For 1 and 3.
1 and 3. It is not returned. So we can wait.
When it takes stage, correct?
Yes, Lordship.
Notice has been issued on behalf of 10-3. 10-3/23.
Yes, Lordship.
Better to take fresh steps, I think. Because 10-3/23 took stage
Yes, Lordship.
for 1/20 that already appeared. 1 and 3 still awaited.
We can take test, no problem.
Take fresh steps because
Yes.
already 1 year left.
Okay, Lordship. No problem. Test steps on 1 and 3.
1 and 3, yes.
Yeah, 1 and 3.
But it was an order dated 17/2023. Watch it. The day after you have taken steps.
Yes.
No, I don't know.
We'll take test steps, no problem.
Or Mr. Yarado for the cause of picture and Mr. K.K. They run stepping on number that happened from office note dated 2024 said that subjects neither the answer nor a record returned for number 1. It reveals most of said that the steps were taken for the record number 1 and 3 on 10/3/2020 and then the crowd reportedly directed to take rest on opposite party number 1 or 1
1 and 3. Test
to
steps.
register this record.
Much obliged.
Call for, not for.
May it please your Lordship. Lordship, in last occasion, the appeal was admitted on 31/5/2023, but the LCR has not been called for, my lord. So, my lord,
Otherwise, appearance is completed.
yes, I'm for the respondent.
You are for the
Yes.
Your MS?
I'm A. Sharma.
H.
On behalf of B. Chakraborty.
Hard MS. Also hard MS M. Sharma.
M.
Sharma. Subject however, it is seen that at the time of admitting appeal, the admission was called for. According to called for the this
Deeply observed.
May it please your lordship?
Yes.
Your lordship, as per office note dated 7/2/2023, your lordship, notices were duly served upon respondent number 1 and 2, your lordship. But
Number
office
1
note,
and?
yes, your lordship, there are 2 respondents. And your lordship, as per office note dated 16/3/2024, LCR is not received.
Okay, now I have come across 4-5 MFA
Yes,
matters.
your
In all the
lordship,
matters,
not
they are not
coming.
receiving the LC.
Yes.
Agora, it is remand that's not content of it. Except to get a remand with except there are 2 services already complete. Hard MS keyboard. It's according. Yeah, again, it makes reminder with the logo.
Yes,
Let
your
us-
lordship.
Please.
Obliged. Lordship, in this case, as per office note dated 22/8/23, your lordship, notices were duly served upon respondent number 1 and 2. There are 2 respondents, your lordship.
Hard keyboard. For office note dated 28 with the number 1. You need the LCR also.
LCR is not there.
We have not
LCR
received.
is not there.
There is no such order for calling the LCR, in fact.
Yes, your lordship.
Notice was, in fact, issued. So, call for
Obliged.
May I please your lordship? I am appearing on behalf of Dr. B.N. Gogoi. Senior is out of treatment. Kindly may fix.
the request not to so he is suffering from what kind of problem? He is suffering from
Mental illness, health illness.
That's what health illness. But you need
Diabetic.
2 weeks, 3 weeks, or
4 weeks.
4 weeks.
Let the matter after 4 weeks.
You are for the respondent.
Mal.
So one I is there, no?
My lord, delay condonation, my lord.
Yes. How many days delay was there?
According to us, it is, my lord, 1,260.
1,260 days.
My.
And as per you?
Lordship, we are for the appeal and Lordship. Lordship, we will file affidavit in reply to the Lordship.
My lord, we filed our affidavit in opposition in July 2022. And since then, my lord, it has come up for last 5 times, my lord, they are seeking adjournment for filing their reply. Because there has been suppression of fact and those has been brought on record by my affidavit. To that, they wanted to file reply for last 5 times.
So now they have submitted that they have already filed their affidavit in reply.
No, my lord, they want to seek some more time.
You want some more time?
Lordship, here
We have already filed.
Today, Lordship, will file affidavit.
You have already filed today.
Lordship.
Think that they have filed today.
We are yet to.
So you are going to file or already filed?
Going to file, Lordship.
That's going.
Next week, my lord, any date for dispute?
You are MS?
D Chaudhary.
You are MS D Chaudhary.
Lordship.
MS D Chaudhary. Your name is not selected.
Lordship, behalf of RDB, Lordship.
RDB. Not Sharma. HP Sharma.
My lord.
One. It is submitted by that they are going to be the affidavit in reply by got some time for it. I want any fix it or after 1 week?
My lord, maybe on 11 Monday.
11?
11
May.
11 is the
Sorry,
holiday.
my lord, 13.
13?
Monday.
13 is the Monday can be.
Monday.
13 May.
13. Okay. 13.
Much obliged.
It's not 13.
My lord, the delay is 23 days, my lord. Only thing
now you are from this side, you have come to this side. Okay.
Only thing is that, my lord, against the title suit, my lord, we prepared an appeal before the district judge. That was within time. But because of the notification issued by our High Court regarding the change in pecuniary jurisdiction, my lord, that record were transferred from the district judge to the High Court. During that period, my lord, there was a delay of 20 days by preparing the appeal here. But if my lord considers the appeal that was filed by me before the district judge, that was within time. And that was also admitted. But subsequent to the notification, my lord, I was directed to withdraw from the court below and
to file here.
Because of that, my lord, 23 days.
Yes, you are paying for respondent?
I am for the principal respondents here.
Only principal respondent?
No. Yeah, my lord, page number 7 may kindly be paid. I could not follow how it is, if it is filed on June, how the affidavit is showing it is in September. Page number 7 at the bottom.
My lord, the connected first appeal was filed in June. The delay condemnation was filed here. The delay is regarding filing of the first appeal, not the appeal. Connected IA was filed on 6th of June. That, my lord, will find in page 12. Page 11, page 12. My lord. And this IA was filed subsequent date, which my lord will find.
So your first for the district judge was filed on?
District Judge, my lord, it was filed on 11th of May 2021. And at page 8, my lord, it was admitted, my lord. 10th of August 2021.
Was A1 of 2021.
My lord. And if my lord comes to page number 9, my lord, this was the order passed by the court below, by virtue of which, my lord, I had withdrawn my. And at page 10, my lord, I approached the registry in pursuance to the order at page 9.
So that the order was passed on 3/2/2020.
Yes, my lord. And then, my lord, at page number 10, my lord, I approached the registry of this court. And then, my lord, at page number 11, my lord, it filed the filing slip on the right hand side top, my lord, 22nd of June 2020. And at page number 13, my lord, will find the calculation by the filing department of this court. Page number 23. There also, my lord, the delay has been considered till 21st of June 2022.
What had happened during that time? There was jurisdictional point was there.
Yes.
Some cases were transferred initially even from High Court to our court, then the district court. From the district court again, it has to be transferred to the High Court. So these sort of things were going on. It is a fact. It's not thing. Because I was there at the district judge here at Kamrup in that case. We faced that problem also while I was there.
No, only
So that is there. In any other submission, because there was a delay of how much?
23 days. As per
So
their
that was there in fact. So, so can be delay can be condoned, or is there any other submission from?
No, my only submission is that if the affidavit they have supported in connection with this petition for the to condone the delay, it shows that I signed this affidavit just on this day of September. That I could not follow. Whereupon this September has come.
So he's saying you have filed the
Page
affidavit
number
in
7,
September.
my lord, the affidavit my senior is referring to, that is in connection with the IA, delay condonation petition, not with the regular proceeding. My appeal was filed on 22nd of June, and subsequently I came to learn that there is a delay, and there pursuant thereto I have filed this IA in the month of September.
So RFA, the first your appeal was filed on 22nd of June.
My lord. And this connected IA, my lord, when I filed my appeal, my lord, then I came to learn that there is a delay of 23 days, and thereafter I filed this IA seeking condonation. And for that, my lord, at page number 7, it is September 2022, because I filed it on 6th of September 2022.
Your affidavit is in page number?
Page number 7, my lord. This is in connection to the IA note of the RFF.
But you have filed the IA on which day?
6th of September 2022.
6th of September.
Month.
So in connection with the IA only he did that affidavit was not?
Yes, ma'am.
Okay then. Well, as per his submission, he first initially filed the RFA on the 22nd of June.
Yes.
Thereafter only the most IA has been filed.
Regarding this, actually they would ought to have made a statement in the petition. Anyway, however, I leave it up to the lordship.
So at present there is a delay of 23 days.
My lord.
Applicant, not participant.
Dinner.
Contributing of it in but RFA against it. Four seven was by that just very that number 29 the drama that on the head state business it had already gave certain appeal before the teacher verified was this that number 01 of 21 and focus and 44 package right order did according to the episode that right order did can take the subject number 87 Roman 5 test 20 test 641 public A dated 7 21 for 1 to 15 should was right in what again from the book know about the present need connected RSS 5 with the job for the term you will connect that part of happen but point wait for after like that await didn't be that I must like at it earlier architect like of book and are there it is not numbered.
No, madam. No, it is not numbered.
It's recorded that
My lord, the RSP will be listed for admission. Much obliged. Deeply.
I
36.
May I clear this? I matter on behalf of B. Buragway. Such matter may be taken after one it says he is unable to present before an honorable court due to his illness.
But he could have informed it earlier. Today is a
where he was working. Could have given the information earlier in the morning hours.
Actually, over telephone he asked me to.
Later on you come. Are your Mr.
B. Buragway.
Understood.
S. Sharma on behalf of Bishop.
After 2. After
Lordship.
at
Obliged.
It be pleasure, Lordship. So now in this appeal, there are two types of that is the private respondent number 1 and 5 already been appeared, my senior. And other respondents are the State of Assam and Deputy Commissioner, etc.
so 1 and 5 are the private response. As
Yes,
it is.
yes, my lord. 1 and 5 are the private respondents, and 2, 3, 4. The 3 respondents are State of Assam, Deputy Commissioner, Circle Officer. My lord, this
GA can represent it. Government advocate can.
advocate can represent. I may be able to submit that they have not filed a contested suit, as because it is a fight between the brother and sister. He is a sister and I am the brother.
It is a dispute between two private parties.
Brothers regarding the mutation. As the government has no role in this case, I may be submit, my lord, that the case may be fixed for hearing. Admission means Your Honor.
From the government advocate.
Yes, my lord. That initially the appeal was filed in the district judge, but due to the pecuniary jurisdiction, the record has been sent to this honorable court. So, another order may be passed by this court, by this honorable court, to admit the appeal. Whether it is necessary or not, I do not know actually. But appeal was admitted in a district judge.
In absence of the government.
In absence of the government, and the respondent number 1 and 5 appeared in the district judge, and the record has been sent wholly to this honorable court, High Court, due to the recent amendment of the Court Act. Now, the respondent number 2, State of Assam, 3, Deputy Commissioner and Circle Officer, 4.
At present. You can inform any government advocate.
If necessary, my lord, I will take a fresh steps.
No, one government advocate represented. Okay. Otherwise, what is the office note? Is there any? No.
Office note is vague, my lord. There is no any indication in the office note. Your lordship may come to 26/5/23, the office note hearing. There is nothing, my lord.
Trying to inform one government advocate.
My lord.
For anyone witness. That's for 5 people. Just for 5 people.
Yeah, but
May I please your lordship? Lordship, today I furnished the copy of the petition lordship.
Lordship, today we will going to file Wakalatnama in item number 38, and in item number 40, my lord, we need some time to file Wakalatnama. In item number 38 and 40, we received the copy.
38 and 40.
38 and 40, yes. So we will going to file Wakalatnama in item number 38, and in item number 40, we will going to file by tomorrow.
So, in both the matters, the sole respondent.
Yes, ma'am.
LCA has already been.
LCA is there.
Both the cases. Order. UIMN?
NN Sharma.
Her name is NN Sharma. Also, her NN Sharma. Yepe. Wakalat. By. Robo in item number 2 in 40 art NSF on it number 95 prayer up 40 and LCR has got and record. Okay, now over to people.
Yes, ma'am. Much obliged.
I'm preparing for the respondent lordship.
So BT does absent.
LCR is-
Epic was already admitted for hearing.
Yes, lordship.
We have received the LCR also. Unadmitted call for Epic. Hard deputy
CCC lordship. RDB.
RDB. That is MSR. LCR has also been received. And record for it after report.
Obliged.
May it please your lordship. Your lordship, in this case, respondent number 124 has already appeared, your lordship. Your lordship may peruse the honorable court order dated 22/9/2023. 1 to 4. Yes, your lordship, already appeared. And your lordship, as per court order dated 22/9/2023, respondent number 5 has already been struck off. 22/9/2023.
5. Respondent
Yes,
number 5.
yes, your lordship. And as regards respondent number 6, it has been struck off at a delay stage, your lordship.
So that name respondent number 5 was struck off. And again?
In by order dated 21/8/2023, that is at the delay stage, your lordship. Respondent number 6 has also been struck off. That is at the delay stage. 5 and 6 has been struck off.
5 and 6.
Yes, your lordship. And respondent number 1 to 4 has appeared. SDR has been received, your
Okay. Yeah. The respondent number 1 and 4 are directed counsel. And by the order dated 29, the name of the number 5 or the struck off from the outside of the memo of the and the name of the respondent number also has been struck off. By order dated 28/2020 in IA number ISC number 119. That the of the and has see matter is admitted now.
Yes, your lordship. Already admitted.
It's according to 48.
Obliged, your lordship.
Lordship, he made me wait here. He made Lordship wait here. Then again, I caught him in court number 16, where item 44 with him was there with me. I told him that you make me wait here, and then you are sitting in 16. Then he has come.
Lordship, Since my senior is not fit till now, the division bench.
So what is your submission? Why don't you contact your senior?
I take him instruction.
Simple is they are not filing the IA. So how can you enforce them to wait for some time and to file the IA? Deposit of 50% and all. How?
This is a ये case Lordship statutory appeal. They cannot have anything to say. Lordship can hear him and then admit it.
Number 3. He is waiting there.
Lordship,
we are giving you time.
I apologize, Lordship.
Now see, the question is that simple question. The statutory appeal we can admit. There will be no harm for you in addition the admitting
exactly.
the appeal. And that apart, the the stay matter, they have not filed the petition yet. Let them file the petition, and that regard you will have definitely will hear you. Or regarding the submission or deposition of 50%, 60%, whatever, that matter can be heard and decided itself. On the same matter, but till now they have not filed. So how can you insist them to deposit 50%? That is the problem.
I have contacted with my senior. He is on election. Then I am the only one and only his assistant, Lordship. Associate. Then there is item number 14.6.
Counsel for the applicant. And also heard your good name.
K.M. Bora, but Lordship, he stated that he has some submissions regarding these applications.
Lordship can admit it. It doesn't matter. He has spoken what he wants to.
So notice, instance of notice is not required. We have already appeared.
Yes, we have.
Is there any other respondent?
To them also we will serve Lordship because all of them appeared because there was a delay petition.
However, we will issue notice. Then.
Yes, Lordship.
Issue notice.
We'll serve them.
Other respondent. Also call this recording there.
Highly obliged, Lordship.
petitioner पे हूँ पार्टी की नाम से
for respondent number 2, 3, and 4.
I'll be appearing for respondent number 3 and 4, GA Assam. And respondent number 2 is represented by Standing Council Revenue Department.
Standing Council?
Revenue Department.
Oh, acha.
Mr. Arbor Borpuzar is there.
Okay, then so you are going to represent 3 and 4.
3 and 4, madam. Deputy Commissioner and the Sakalo.
Okay. Second. After the council for the epic, not hard. A4. Pick it up, epic. 1. Oh, 1. Mr.
J. Singh, my lord. J. Assam.
J. Assam. Presented the response number 3 and 4. You notice according to number. Otherwise, so just take steps. It's the formality. With next time, it will.
Registry may be directed to reflect the name of J. Assam for respondent number 3 and 4, and for respondent number 2, SC Revenue Department. And extra copies may be furnished.
And then it also otherwise, what we mean, we have LCR we
LCR has already been
read.
LCR
has got
extra copies of the petitioner.
Extra copies of number. So we are listing the matter for in admission column next week. So in admission stage itself, if it is already ready, we may dispose of the matter in presence of the Standing Council for the Revenue Department. No, she is saying LCR, we have not received the LCR.
LCR has already been sent, my lord.
Already
That
been
is
sent?
that is later, my lord. That is page 13. Page 13, that day from the district judge office forwarded the original case record of the title appeal number so and so.
Page
And
number 13. Page number?
page number 13, your lordship. But
No,
they
maybe there, but physically, most probably we have not received till now. It's obviously the order is there, but that's it. No, not called for. It has already been sent.
already been
That, but
already
we
been
have not received till now, so we may call
8
for.
to 2023
Yes,
by
obviously.
later.
Yes, obviously, but it can be what can you go for any?
Office may be directed to locate the record, my lord. That is there may be in the office.
It is not possible to my lord, it is formal admission order is not there, my lord.
No, not at yet. So
Only
we are not
because-
going to
no,
admit
only
it.
because of that, my lord, record has not been called for. Maybe, my lord.
No, maybe, but from his submission, it was saying that in page number 13, the record was also sent from the district judge. It may not reach at that point.
Yes, my lord. That
Can we pass an order? That's what we have. Okay. So what we'll do, we call for the LCR. If it is already there, then Dr. Stacey will definitely give us the note. In
My
that,
lord.
if it is already there.
yes.
Fine. Which we will district for admission hearing, we call it for the LCR. If it is already here, then we can.
Yes, your lordship. Lordship, as per office note dated 24/4/24, lordship, service was not complete upon respond number 1 as it was not found, lordship. Respond number 2 is duly served, so we want to take steps by newspaper publication. (24/4/24).
Who is already served.
2 is already served, lordship. 1 we want to take newspaper publication. His address is of Nagaon, lordship, so a vernacular newspaper with
Do you have any other source to know his present address?
the address we have taken from the claim petition, lordship.
Take it. Dusty will not serve your purpose.
Dusty.
Because paper publication are the same thing. But as per the office note, he is not available.
Yes, he could not be found.
Paper publication also. It is purpose is not served, even if the paper publication hardly served. So why did you take 1 chance to raise
Dusty.
Dusty? Inclemency. Clear? What? Hard distance.
SP Sharma.
From the office note. It 24 for 24 how the answer on the number 1 with a posted mark but on the not known comma return then the and then that
Obliged.
May it please your lordship.
You're referring for MS Roy?
Yes, lordship, with your lordship's due permission. I have gone through the office note. I have seen that respondent number 1 and 2 lordship service report returned back. It says that they are not found. So appellant may take fresh step in appropriate address. But I have gone through the judgment. The address which is in the MFA is the same in the judgment also. So if she can take out any further address.
Should I write appearing on behalf of? Appearing on behalf of as per it's not 24 the answer for the written for 1 we note that address is that and regard that like rather than problem that for their interpret the problem
After 4 weeks. 4 weeks. I'm deeply obliged.
No, please, Lord. The IA is for condonation of delay of 67 days.
So this has come for the first time?
Yes, Lord. For first time, notice in Lord.
Have to issue notice first. You are Mr.
PJ Burman.
Burman. Report. Delay was it? How many days?
67 days of delay.
7 days delay. Appeal.
Appeal.
Judgment and order 7. As by the Commissioner for the employee company and company now come and the case number 27
Obliged. Also, by register post.
Yes, obviously.
Obliged.
May it please your lordship. Lordship, in this case, LCR is there, so lordship, the matter may be fixed for hearing.
So you have appeared for
Respondent.
all
Sole response.
sole response.
Yes.
They both Sharmas are appearing together.
Only difference is the initial of my name, my lord.
RFS counsel for the appeal. Sharma, that is not the appeal. No, but we are 47. So, see, was it again?
Lordship, I am appearing on behalf of K. Gogoi, Lord.
Oh,
K. Gogoi.
CGC.
Lord.
Okay, okay. Appearing on behalf of K. Gogoi. For CGC. Actually, for CGC. That's all. On after four.
Leave your lordship.
May I please?
Yes.
Please for early hearing, your lordship, because the LCR has already come, and
This application is filed for early hearing.
yes, and already the original appellant expired during the pendency of the appeal, and substituted, your lordship. So any date in the month of June or in the Part 2 list of June.
So, do you have any objection? Otherwise, it was not listed for hearing. What was
No, not
It's a matter of 2018.
18. The last order, it is stated on EGL course. Because of that, I have filed this petition. Your Lord. Any date or Part 2 list of June.
It's in for early hearing of the connected appeal RFA number 53 of the in that context, Mr. Ganguly of according to their the IS and record study. Record in view of RFA in view of order passed in IS with 729 and it's a matter for hearing on get want any date fixed.
Any date.
You want any date on month of May?
In June, your Lord.
In June.
In the month of, he said in the month of June. Let it come.
In the month. First 11th.
11th.
Just make us, I mean, the first of us reminder that there was a petition for our debate, so that matter can be heard, because sometimes it happens that hearing, 2 hearings, after reaching 3 hearings, other matters cannot be.
Yes.
So otherwise, we are fixing on date of 11th. ISD.
Obliged.
Yes.
Lord, this transfer petition is filed for transfer of one case, that is title suit number 48 2023, Lordship. And the originally this transfer petition is filed. Originally, the transfer petition was filed a different advocate, Lordship, different counsel.
Now, Lordship, what I have noticed here that the application is preferred under a wrong section, Lordship. In the cost title, Lordship, application under section 407 with section 482 of this CRPC, Lordship. So I had to go for the amendment.
Yes, definitely. No, where it is?
In
the transfer petition itself, it is saying that under section 24 only.
Yes, Lord. Yes. The transfer petition.
Where?
No, I have not got that, please. This could have. Is it correctly noted, ma'am?
Correctly noted, 24 only.
Yes.
Not 48. Is the title? Transfer petition. Actually, Lordship, I was engaged recently, and this was the copy given by my client, Lordship. So
you better to withdraw this one because there is no need of any correction because already this appeal is, the transfer petition is filed in the correct and it's 24 only.
Yes, ma'am.
So I don't think it is.
Lordship, there are some more submissions.
Maybe some confusion on your part.
Lordship, here in the transfer petition, the prayer is made for transfer of one case. But however, later on there are two other petitions filed. Cases preferred. One is guardianship, and the other one is restitution. Lordship. Now, in the cost title and the prayer portion, I'd like to add those portions, Lordship, at least, so that all the cases taken up together for transfer. Lordship.
No, my lord. This interlocutory application is.
No, that too, I'll ask him to withdraw this one.
Yes, that.
Because the matter is preferred under proper section, but the question of the transfer petition, he wants to add his prayer for transferring the other matters.
Yes.
Also. In that case, if there are any objection.
No, actually, this I is neither, my lord, factually correct, and nor it is admissible because, my lord, your lordship may kindly see page number.
No, just a second. By this I, what is his prayer?
His prayer is, my lord, for amendment of the CRP.
CRP
means, my lord, it is transfer petition.
Yeah.
Lordship, in this IA, Lordship, I did not see it actually because this was.
Here you have filed this submit. You have submitted
Lordship.
That it was under 482 or whatever.
Lordship,
These are not here.
Yeah, that is what, Lordship. Actually, I did not see this court's record, Lordship. I have it was given to by my client, Lordship. So that is where the mistake happened. But Lordship.
Do one thing. So by this petition, he wants to incorporate the other prayers through amendment, isn't it? So in that case, if you have anything to say,
yes, my lord,
you can file your objection. You can file your objection because in one prayer, the other petitions may not be.
No.
Why don't you by amendment? In amendment, it will be the entire structure, entire things will be amended now because it is purely a petition for transfer of the episode report, whatever was pending, and thereafter two other cases we have already said. So
it's not possible.
The entire character.
The rest two remaining two proceeding which you want to transfer was filed by him only. The divorce petition earlier was filed by me, by the wife, but later on what you want to transfer, those two proceedings are filed by him only.
If it is on the hearing on the point of transfer, then I have a lot more to submit.
No, yes, that's what I am saying. Hearing petition, definitely, he may file. I'm not. But the question is that incorporating all those amendment prayers in one petition, that may cause it. That's why I'm saying if you if you have any objection,
I will file. I'll file my.
Or rather, you can file. Don't go by the complications and also two other petitions. You can file those may be listed together or same purpose, same. Your purpose will be same. That may be heard or listed together. All those petitions. If two petitions.
But Lordship, at the same time, I have a prayer in the original petition. Also, I have a prayer, Lordship. There is. Because I have cancer, Lordship. I cannot travel to Jorhat every time that it's Lordship.
We may consider. I don't know what is the.
There is an interim stays required, Lordship, for that. Interim stay, Lordship.
Divorce
Lordship,
cannot be.
Lordship.
We may fix a short date. We may fix anything, but so just you come for the divorce first, then
The present I filed Lordship at page 10. My the cancer I Lordship as page 10 Lordship. It is my position is deteriorated in fact Lordship. So next date is fixed.
is your in a divorce suit.
Yes, Lordship.
Definitely, your presence is required. But
Right.
if you file any prayer for representation, the court considering your health condition, that may be considered, I think, by the court. Because generally, the court is regarding if suppose a cancer patient, definitely that cause may be considered. But the question is that it's an amendment petition. The amendment petition you cannot pray for the
I
stay
have
of the.
in the original. I have the original petition. I have the prayer Lordship till it gets amended. So in that
original prayer.
Yes, in the original prayer, there is a interim prayer Lordship.
Yes, where?
As page 8. Is it page 8?
Page 8.
8. Page 8 is this Lordship. Prayer portion. At least till it gets amended, finally if this consideration is made, Lordship. Next date is fixed on 10th of May, Lordship.
The next date is fixed of 10th of May, but it's for further PWs of the, my lord,
no,
complainant, my
no,
lord. He may file a representation. His presence is not at all necessary in that. So the matter was already heard by another bench of the Honorable Court and on this point of stay, but the matter was not stayed. So may I pray not to stay the matter, my lord.
Lordship, the intricacies of in the matrimonial matters, Lordship. Here is a question of guardianship. On the next date fixed, the presence of the minor daughter and the husband, the applicant in petitioner in this case, will be required at the time of hearing, because lots of questions will be asked. The daughter will be cross-examined, or the court will be asking the daughter her convenience, her welfare. In that case, Lordship, his presence will be required in that. That is why my prayer is,
But
Lordship.
before us, that case is not before us now.
Yes, my lord.
Your guardianship or the other two matters are not before us at present. So at present, we are dealing with the transfer petition regarding the divorce or title dispute, whatever. So now that in that case, it is the case of the submission of the most probably the evidence by the applicant. That regard your presence may
At the
be
same
required.
time, there are two other applications.
Two others,
hearing.
so they are not before us now.
No. I mean, in the divorce petition, Lord. In the divorce application, there are two other interlocutory applications for hearing.
There.
So not only that, they will be adducing the evidence. And in the mathematical matter, it is very much required that I keep on getting instructions from my client with me. So it is that way. It is very difficult. Lordship.
It can be before, you can file a petition definitely before the running court below. If your matter is, suppose your health condition is serious or you are seriously ill, as you have submitted that you are suffering from cancer. So that may be one become from before matter. But the rest of the matter regarding the production of the child and all, that has to be decided by the court itself, because these are not with us before us. So I think that immediately before the next date of listing, you can file the transfer of those petitions also. Those matters may be listed together, so we can hear. But stay of the divorce may not be a problem. Or we will pass the order, but stay may not be considered. And now come to IA. IA means what I'm saying, that in a IA, prayer for all the transfers. How can you bring all the transfers in the one IA in one petition? Because there are two, three other cases. So those two, a prayer for those two, transfer of those two cases, I think it will
Those
not
are
separate.
Actually, those are clubbed together. All the
together means, yes,
at the time of hearing in the court.
petitions are there.
Yes.
One guardianship, one may be there. While dealing with the divorce matters, these two petitions generally used to come, all these petitions. So those are there before the court below.
I thought since
now the production of the child is that is fixed on when?
It's 10th of
May. So you can somehow manage that one, because we are not. This is not before us. So now IA, do you want to submit any written objection?
I filed my return objection.
Or filing just, I'm just saying you, if you withdraw this one and by
I'll
the
withdraw,
time
Lordship.
you
I'll
file, if you file two petitions,
I'll withdraw.
that we can club together.
I will
in
please
one.
case and then I'll file. I'll not be. It will not be actually. If I file separate applications, it will be the. I'm thinking about the precious time of the court, Lordship. In that, like if I file three separate IAs for the three cases, so since the matter of the husband and wife.
IAs in a sense, if one suppose mainly you are insisting the production of the child on the 10th of May, that is your main hearing.
Lordship.
So in that case, you file a petition, transfer petition of that case also, supported with an I also. We can hear the petition.
So Lordships,
Before 10th of May, you can file.
all the three separately I file, Lordship, or
I think it would be better because prayer for transfer all the petition in one petition may not be.
Lord.
So in that case, I'll pass the order of withdrawal and immediately before 10th of May as the date, or if you can manage the 10th of May anyhow because he is a consultant, so that may be considered by the court. It's not so thing that everybody has the sympathy for a petition also. So in that case, you may get a time for 10th of May, or if prior to 10th of May, if you want to file any the case supported with an IF, we can. Because one stay will serve your purpose, I think, if all the petitions are there before one court. That will
I'll file three separate.
Three separate, and once in especially in the urgency matter, you file a petition for stay also. We may consider. We definitely will file.
I'll wait, Lordship.
So we'll pass the order on IA. As per your submission, we'll pass the order on withdrawal. Disposed on withdrawal, and the other rest. What is the other matter? The transfer petition is at the stage of what stage? The other transfer.
I have entered my appearance, and on the last date, the petitioner was directed to produce the present status of that
Yes, that is
petition.
in state. Oh, yes, one order is there.
In fact, I have submitted with my
Status report of the proceeding.
Yes. I have in fact submitted the status report, all the cases, Lordship, in my IA.
No, but there's the order of the court on 3/4/2024. Our order was passed for filing of the status report of the present case. That is the transfer one. That is the divorce.
I filed it
have
on.
a Pisanic status report. Oh, that's no, right. So regarding the present status of the transfer petition of the in regards to that, so do you have any? You can file. Can I file? He has no. You have the status report.
Lordship. In fact, I have seen in the e-court services, Lordship. So from the e-court services, I have seen the status and accordingly I printed and submitted. Otherwise, I have one certified copy I have obtained when the date was fixed on 10/4/2024. That is at page 12 and 13, Lordship, in the IA.
Now see here, you have obtained the certified copy on 26/2024.
Yeah. The date.
Date is on fixed on 10/4/2024.
Lordship.
This is one order is here,
Lordship.
and the rest of the thing you have obtained from the website.
Lordship.
But you have filed all these things with your eye only.
Yeah, Lord. That too, my lord. This 10/4 is not correct, my lord. Now the date is fixed on 10th of May.
No. At that time I filed, that was the date. Next date was that. At the time I have filed.
The petition was filed on 18/4, my lord. This I was.
Yep.
Anyways, my lord, the next date is fixed on 10th of May for further PWs. That is the present
No.
state.
Here we are going to file this case when.
My lord.
Here we have filed this case for the transfer is there, no? Transfer petition is there.
Yes, my lord.
So status report we do. You can also apprise the court regarding the status report. So for that I'm not going to adjourn the matter. So it may be heard on the next. So as per your convenient date, what will be the convenient?
30/05.
30. transfer petition 304 আর order করব টাকা দিতে you can hear me better but আর I okay just
Madam.
you also apprise the code what is the status of the code 40 yes yes more mistake on my part I think it already order it was there so I thought that yes 42
My Lord, I am for the petitioner, the Food Corporation of India and others. Official note says that ID card has not been returned
not yet
after service. So,
we can await but the question is that if you took steps I think the order office note is 9/10/2023
yes, we have taken step. We have issued notice.
Okay, you want to await this time?
Yes, yeah.
Await sub. But you are MS? You are? Means?
Deji Pegu.
Part MS Deji Pegu dependent on for the applicant. As per office note dated 9/10/2020 service would for respond service David. Okay, we are waiting for 2 weeks. If it doesn't come, then you have to take rest. For 2 weeks, we are joining.
May it please your lordship. My lord, in this my lord MFA, my lord, we have filed an MFA, my lord. On the last occasion, my lord, the sole respondent, advocate for the sole respondent, informed that the respondent died, my lord, during the pendency of this appeal, my lord. So, my lord, we have filed substitution petition, my lord.
This is I for substitution.
Yes, my lord. Substitution along with, my lord, condonation of delay and, my lord, setting
So
aside.
one condonation is also there.
Yes, my lord. Condonation and setting aside abatement, my lord. Because, my lord, died on, my lord, long back, my lord. Expired on 2021, my lord. But, lord, it was informed by the respondent only on the last occasion, my lord. That is, lordship may kindly see 20th of February 2024, my lord. It was informed, my lord.
So we have to we have to issue notice first in both the matters.
Yes, ma'am.
Let us hear first the condonation and then we come to the substitution.
Ma'am.
Otherwise, only sole respondent was that he after his expiry. Now, but the MFA, Mr. S.S. Roy appeared already.
Yes, my lord.
They do not.
Not appeared.
Good.
Z. Guswami, my lord.
He comes for the
Ma'am.
I what is it? One one I one one. Six get five four six I I'm for the to get care of respondent who died on
28 12.
28. Otherwise, he already appeared. Na?
My lord.
So, can be instead of if you can inform him also,
Yes, I'll inform him. I'll inform him, my lord. Partly.
then he better pardon.
Yes, my lord. My lord.
After to at this council, if you can inform.
My lord. My lord.
My lord, there is delay of 97 days, my lord. It is for the first time. Let know.
17.
Let
They
me-
will not
Yes.
get them and help them. 4 weeks, 3 weeks, or 4
3
weeks.
weeks. 3 weeks.
3 weeks.
Obliged, my lord.
But this is an application for continuation of delay. 58 days, Lordship.
58. This is come for the first time.
First time.
Hard MS, hard answer. It's according to text it for the respondent.
In both process, registered post as well as individual
and
post.
educated. For homework.